Hi, I'm Ren Fizewski, and I'm an advocate with the Disability Law Center of Virginia. In this video, we will be discussing the rights of residents in nursing homes, specifically the right of readmission after a hospital stay. There are times a nursing home resident may require a higher level of care, need an inpatient evaluation, or may simply want to go on vacation to see family. When this happens, a person is sent to the hospital or goes on therapeutic leave. But what happens when they are ready to be released? Before we answer that, perhaps it is best to understand Virginia's policies regarding bed hold coverage for hospital stays and therapeutic leave. It is important to know that Medicaid does not pay to hold a nursing home bed for hospitalizations. Unless the resident or their family pay to hold the bed, there is no guarantee that the resident can return from the hospital to the same bed. Same is the key word here. As for therapeutic leave, Virginia Medicaid does cover up to 18 therapeutic leave days within a 12-month period. During these 18 days, Medicaid will pay to hold the bed of a resident if that leave is within that person's plan of care and noted in their chart. Therapeutic leave includes visits to relatives or friends, as well as admission to a rehabilitation center for an evaluation. What that does not include is inpatient hospital stays. So back to the question. A nursing home resident is ready to be discharged from the hospital or come back from therapeutic leave. What happens now? While the hospitalized resident may not be able to return to the same bed if it has already been filled, they still have the right to be readmitted to the same facility to the next available bed in a semi-private room. This right applies to all Medicaid residents as long as the resident still requires nursing home care and is eligible for Medicaid nursing facility services. Seems easy, right? But sometimes it's not so simple. There are times when a resident may be late on payments, or struggling with behaviors, or having complex medical issues. If someone with one of these issues is hospitalized, do they still have the right to readmission? The answer is 100% yes. A nursing facility is required to readmit a resident even if the resident has an unpaid bill, the facility considers them to be a danger to the health or safety of others, or the facility claims that the resident's needs cannot be met by the facility. Regardless, that facility must readmit the resident. Once that person is readmitted, and there is still a justifiable reason for transfer or discharge, the facility could then begin the discharge transfer proceedings by following the requirements set out in state and federal law. Hey, that sounds like a topic for another video. Anyway, it's all well and good to have these rights to readmission. The first step, however, is knowing these rights. But whose responsibility is it to inform you of these rights? The answer is the nursing facilities themselves. Nursing facilities are required to have a written policy regarding the readmission rights for those whose hospital stay or therapeutic leave exceeds the state's bed hold period. Furthermore, they must provide 2 written notices regarding these policies and the right to readmission. This notice must state the duration of the bed hold policy under Medicaid, the facility's bed hold policy, and their readmission policy. One notice must be given at the time of admission to the resident and their legal representative, long before a resident may need to be transferred to a hospital or go on therapeutic leave. A second notice must be given when that resident does require transfer to a hospital or for therapeutic leave. In addition, the state provider manual states that the facility must post a notice regarding readmission rights in a conspicuous place accessible to residents and their families. This can be a common room, a day room, or some other accessible space. Also, every resident's record must include a statement signed by the resident or their legal representative that they have been fully informed of their right to readmission. All of this sounds pretty complicated, but luckily it's all written down. As Medicaid providers, nursing home facilities are required to document each discharge, the date of the hospital admission, the date of discharge from the hospital, the discharge destination, and, if that destination is not the same facility as before the hospital stay, the reason the resident was not readmitted. Nursing homes are also required to have follow-up contacts to ensure the resident is offered the next available vacancy. This offer must be made in writing and signed by the resident or their legal representative. If the resident was not readmitted, the nursing home must keep documentation of the reason why the resident was not readmitted at the time of the next vacancy. The only exception to this documentation requirement is if the facility has already submitted a letter to DMAS stating that the facility routinely holds beds for at least 12 days for residents discharged to a hospital, regardless of whether anyone is paying to hold the bed. Of course, the system isn't perfect. Unfortunately, there are times when a resident is sent to the hospital and, despite their right to readmission, the nursing facility is refusing to readmit them. So what do you do then? There are a few options here. First, the resident, legal representative, or family member should contact the local long-term care ombudsman. The ombudsmen are advocates for adults receiving long-term care services, such as those in nursing facilities, and they provide information, advocacy, and assistance to help resolve care issues. Speak to your local ombudsman to see if they can persuade the nursing facility of their legal obligation to readmit the resident to the first available bed. You can also contact the Virginia Department of Health's Office of Licensure and Certification. They oversee the licensing programs that cover nursing facilities, and part of their responsibility is to investigate consumer complaints regarding the quality of care received. If the resident is on Medicaid and still needs nursing home care, the resident can also promptly file an appeal with the Department of Medical Assistance Services, or DMAS. This initiates a hearing to determine whether the facility acted properly and whether a resident's rights were violated. It is important to act quickly on a failure to readmit case, and the appeal must be filed before the date of the threatened discharge. Furthermore, such appeals take time, and the hospital will be eager to discharge the resident as soon as possible. A resident may be forced to be discharged to another facility, one which could be miles away from family and friends, if the first facility refuses to readmit. However, you may be able to return to the original facility through an appeal. As a nursing home resident, it is important to know that there are protections in place for you. Even if you are admitted to a hospital or go on therapeutic leave, you still have the right to readmission. If you have any questions or need additional assistance, you can contact the Disability Law Center at 1-800-552-3962. You can also visit us online at dlcv.org for more resources. Thank you for watching, and remember to stand up for your rights.